ringing up Jonathan Smith.
Hello, you've reached the voicemail of Jonathan Smith at DWF Law. I'm sorry I'm unable to take your call at the moment. If you'd like to leave your name and number, I will of course get back in touch with you as soon as I am able. Thank you.
Please leave your message after the tone. To re-record your message, key hash at any time.
Oh yes, hello Mr. Smith, it's Mr. Hussein here. Regarding your recent email that you sent me yesterday. I have obviously, as you know, I've been trying to contact you for a conference call appointment booking. I've sent you numerous messages over the intervening days. I believe I've been sending you nearly a daily message to engage with me for a number of days, all being ignored. But then finally I did receive well, I would say a lengthy email response from yourself yesterday, the 31st of October 2023 at 8:20. I'm just conscious of the fact that this is a voice message and it's going to end soon. So I just want to let you know that obviously, as you may have established or gathered by now, all my calls are recorded, and it's my policy to usually publish my call recordings when I sense nefariousness and malevolence taking place. If you're not aware, all my calls... I'm adopting the same policy. I'm going to be adopting this from now on. I'm going to be adopting the same policy that I've been adopting with the local authority, whom I believe has given you instructions to act in this manner of avoiding to engage with me in conversation in aligned with their vexatious complainant policy. So the local authority since 2019 have created a vexatious complainant policy specifically designed for me, because in September 2018, after my brother Talib had been kidnapped into their care and custody, I made it quite clear to the local authority through their complaints procedure that it is my intention to record all my interactions on calls with them, and I had quite a lengthy conversation with the complaints manager at Bradford Council. They said that they're going to take legal advice on this matter, because obviously she did not feel comfortable being recorded without her consent and permission, and the call subsequently publicized. That matter was left with the council in 2018. By 2019, they've vexatious complainant policy in place, basically trying to circumvent my civil rights to record the conversations I'm involved with, and my citizen journalist rights to expose fraud and corruption. So what I'm going to be doing now is I'm going to leave you a message. This call is being recorded. I'm then subsequently going to proceed to publicize it, and then send you a link to it so you can hear the rest of the call, because as I can appreciate, this call is going to cut out any minute now. So I'm just going to make you aware that I'll be then subsequently sending you an email regarding this voice message that I'm leaving yourself, because I need more time, more comprehensive time than your voicemail allows. And as you have also indicated that you're refusing or do not see the point of me engaging with you directly orally, I believe the reason that you're taking this stance is quite clearly in line with the council's vexatious policy. The solicitors at Bradford Council have instructed you, and I can evidence this, because otherwise why would there be a reluctance on your part as a representative of your client Manningham Housing to refuse to engage with me? The only justifiable reason for this can only be because of the fact that there is an aspect of collusion. What I want to do today is I want to go through your email that you sent me so I can fully respond to it. It is not a requirement of myself to put things in writing to you. This is the kind of trick or the hack that the local authority want me to follow. They want me to jump through their hoops. They want
Time up in 10 seconds.
The council want me to jump through their hoops, and I refuse to do so. I'm a free man to do as I please, as a free citizen, as a private citizen. So please, the call is going to finish now, and I would ask you to...
Message has reached maximum length. Message deposited. Thank you for calling. Goodbye.
Okay, as I anticipated, the call voicemail for Mr. Smith lasts for about just under 4 minutes, and that's obviously not enough. Mr. Smith is refusing. Mr. Smith of DWF is the Jonathan Smith of DWF is refusing to engage with me in in oral dialogue. I mean, these are not private proceedings. These are public. These are publicly in the public domain, and I think it's in the public interest where I've continuously made ongoing allegations of judicial fraud taking place through a joint enterprise. But I think the best way to start now is to spend some time going through Mr. Smith's email of yesterday. So it reads, Dear Mr. Hussain, I refer to your email and voice messages. So I've been leaving him regular daily emails at 8 a.m. and subsequent voice messages daily for the last, I believe, a week or two for him to contact me, and he's refused to contact me. So he goes on to say, I have been in court and I am still in the middle of a lengthy trial. Well, what's that got to do with anything? You're trying to tell me that your time is so taken up on a lengthy trial when the reality is, I mean, this is quite clearly just spiels that he's giving me, just excuses and pretexts to get out of engaging with me. The reason he doesn't want to engage with me is because he's received instructions. What I believe is he received instructions from Bradford Council not to engage with me because obviously they don't want to let the cat out of the bag. As hence why my last conversation with Mr. Smith was all about who let the cat out of the bag, that the police had come and arrested me. So anyway, he goes on to say that I have been in court and I'm still in the middle of a lengthy trial. Therefore, I am not in a position to have a call with you. I have previously indicated that if you have any queries, then you may email, and I will look at responding to anything relevant. So then he wants me, so you see how he wants to hide behind the corporate veil as a solicitor, as a public representative in court. He's a solicitor. So, and obviously his details, his information is out clearly publicized. So what he wants to do is he wants to dictate terms of communications with me, just as the local authority wanted to dictate terms according to their vexatious complainant policy, that I can only email them at a designated email address, and they will decide whether they want to respond or whether they think is relevant. So they want me to supplicate myself to their judgment and jurisdiction, where they say, well, I will only respond where I think is relevant, because anything else that you ask me on the spot, I may slip up with a Freudian slip and reveal something that I shouldn't be revealing. So this is a clear example of Mr. Smith and others simply looking to engage with me. You on behalf of your client Manningham Housing Association are quite happy and eager to take me to court and pursue litigation action, but you're not willing to speak to me out of court or trying to resolve a situation. You're asking me that I should look to dictating terms of how I should respond to them. They don't pay me. In fact, is it not the case of a solicitor's is their bread and butter to write letters? That's their bread and butter. So that's what they've been qualified and educated to do. They've been educated and qualified to write letters upon which they make their money. So they want me to adhere to their rules and their way of doing things, where they're in charge of how the narrative is to be set. And I don't need to do that. I'm a free person. I'm not required to write anything down. As you can see, I can quite clearly and articulate myself orally, and it can be recorded and it can be referenced even better than a letter. So where they would have me write letters, I can make audio recordings and make videos of them and publicize them so everybody can listen in, rather than Mr. just making a private letters and private correspondence to the solicitor. That's what they want to do. They want to have privacy whilst holding a public position or a professional position. Mr. Smith then goes on to say, as a further point, I would say that I am at a loss to know how a further telephone call would assist in any event. The last time we spoke for more than an hour, and it involved you telling me that my client is part of a joint enterprise into a criminal activities. I have seen no... All right, let me just stop there. So last time I called him, and as on many occasions I've called other people in similar circumstances, I called him on a private number, so he didn't know I was calling on a private number. Soon as I called, he picked up the phone. He said, I've got literally a couple of minutes and I'm I don't have time to speak to you now. I'm very, very busy. And that's just another pretext that they use. They're busy. What they're busy doing, fiddling their thumbs, that's just a pretext to get out of engaging with me. So you told me I don't have much time today. I'm going to a meeting, so I can just give you about 5 minutes. minutes. It ended up being an hour's call. So clearly he was not telling the truth there. And I obviously told him exactly what the situation is, and he was umming and ahhing, because ultimately I left the situation with him. I said, who let the cat out the bag? That's a terminology that I use, because how did the housing association find out about my arrest, that if they hadn't all colluded and conspired to commission that? So obviously that was the call then, and now he's I'm at a loss. I'm a very much a professional person. You should respect my authority. I'm a solicitor. In fact, no, I'm a senior solicitor. No, in fact, I'm a judge, or a your honor, or your justice, or all these are just labels. Are you trying to tell me when you go to the toilet your defecations don't smell? You're just like everybody else. I don't recognize your titles. Yes, in the courts and the judges, they may each look to recognize each other's titles. At the end of the day, if you're refusing to recognize me as a free civilian on this land, and you want me to adhere to your officialdom, then why are you so scared to engage with me in open and transparent dialogue? No, what you want is, basically say, what you want to do is, this is the situation. You want to create a situation of trust, where I trust you implicitly. And the reason I trust you implicitly, not knowing you from Adam, not you not being my solicitor, is because you're a solicitor, and you're regulated by the solicitor's regulatory body. You're compliant to the legal ombudsman. All these other are just spiels, all right? Don't recognize any of these things. You all work together. You're, as I say quite eloquently and adamantly, you're all Orwellian pigs eating from the same trough, all right? So don't tell me that, oh no, you're different and I should respect you. I will only respect people that I see are worthy of respect when they show me integrity and respect. If you're choosing to disengage with me but how can I respect somebody when they are quite clearly committing fraud and deception by abuse of position and authority, and you want me to respect you? Absolutely ridiculous. If I'm going to be respecting you, and I'm going to be respecting everybody else, then the first person I should be respecting is Jimmy Savile, Sir Jimmy Savile. He had titles too. So don't tell me that I should be, you're acting like you don't know what's going on. You know exactly what's going on, and so do I. So let me just read this again. As a further point, I would say that I am at a loss to know how a further telephone call would assist in any event. The last time we spoke was more than an hour, and it involved you telling me that my client is part of a joint enterprise into a criminal activity. I see no evidence of this, and would be duty bound to take action if I did. So he sees no evidence. The evidence is right in front of him. The reason he's refusing to even acknowledge the evidence, all right, and basically he's closing his eyes, closing his mouth, and covering up his ears. So I see no evil, I hear no evil, I speak no evil. It's simply because it's not in his interest to see the evidence, and hence, if he spoke to me, I would tell him, look, there's the evidence, which I'm going to be later on discussing in this call. So the evidence clearly exists there of his client and the housing association, the Housing Association, Manningham Housing Association, colluding and conspiring with the local authority, Bradford Adult Safeguarding Board, with the collusion of the police. Quite clearly, this was all an orchestrated event to kidnap my brother in order to advance their case. So they can just simply act ignorant. This is what I classify as the dumb blonde strategy, where they say, oh, I don't know what's going on, I'm just stupid. And I've gone in front of courtroom judges, high courtroom judges, and they all act like dumb, blonde, stupid retards that they don't know what is going on. Oh, Mr. Hussain, speaking to me with a posh English accent, being very calm and collected, considering the fact that they're being paid handsomely for the position that they hold, and then abusing that position, and all acting dumb and ignorant. And so this is a clear example of acting dumb and ignorant. Diminish responsibility through willful ignorance. This is clearly willful ignorance on his part, when he's stating on the one hand, I don't know what you're talking about, I'm at a loss. What do you mean? You're making all these accusations. I see no evidence of this. And then that alone, did you investigate? Have you investigated? Have you seen any evidence? Have you reviewed my evidence that I presented to you? No, you're not a judge. You've not, and this is what judges do. I see no evidence, therefore it cannot be true. I've made the allegation, and I continue to make the allegation that I'm being subjected to a joint enterprise. Let's go back to this letter. I've seen no evidence of this and would be duty bound to take action if I did. What would you be duty bound to do? Who would you tell? Would you tell the police? Who would you tell the regulators when they're all in on it? In the most recent voicemail, you have explicitly said that I am part of this process and that I am getting instructions from third parties. I categorically deny this. Oh! So you are a solicitor, a senior solicitor, and you deny it now. So therefore what is, I lose my allegations lose all validity. They're not true now, are they? You said no, they're not, and so therefore it's not. So your word, your professionalism, your title, your position of standing as a senior solicitor, you said it no, and therefore it's not. Well, let me ask you this. Are you more superior than the Prime Minister of this country? Are you more superior than Boris Johnson? When Boris Johnson was equally denying, oh no, I didn't attend no parties. There were no parties. I didn't attend nothing. No, I see nothing. There's nothing wrong here. And only now, as you're fully coming, as you and everybody else in society is fully come to lie, he was lying, wasn't he? And so therefore, I put it to you that you're lying. And as a solicitor, as a barrister, as a judge, as the king himself, nothing prevents you from lying. And I have obviously caught you out in your lies and deceptions, and that's why the real reason you are acting dumb and you don't saying, I don't understand why, I don't see no reason why I can't speak to you, because you know the fact that as in our last conversation, that I'm going to ask you some certain key questions that you're going to trip up on and then expose the whole thing like you did last time. You're quite clearly not intellectually that strong compared to myself, and I can quite clearly ask there certain key questions that are going to cause you to slip up and therefore embarrass yourself and expose your lies and corruptions. So that's why you don't want to speak to me. That's the real reason, isn't it? And that's the real reason that Mr. Kenner from Bradford Council Solicitors and all the other people don't want to speak to me directly, because they know they can't then word things in writing to prevent from Freudian slips taking place and being challenged and put on the spot. You don't want to be put on the spot, but you want me to be put on the spot by getting the police to come and raid my house and kidnap my brother and take me on a police interview. You would like me to be on the spot. That was quite clearly an abusive position. But let me just continue with this letter of yours. So it goes, I am unwilling to have my client incur further charges engaging in communication which make these baseless allegations. Who says they're baseless? Have they been investigated? You say they're baseless because you are being put on the spot. You are being put to account. I'm making these allegations, and these allegations, may I just add, Mr. Smith, that these allegations, your involvement, you're only a small pawn in this quite complex web that's been weaved. I've made the very same allegations, and as I have been making regarding many senior justices and senior high court judges and circuit judges and district judges for a number of years. In fact, you should just Google me. I'm easily Googleable. If you just Google the term Shahzad Hussain railroading by Bradford Council, my whole story will come up. How exactly did I get criminally convicted of defrauding my own brother in 2016 when they had authorized me to do so? And so this is the background in it, is the criminal conviction. I don't care about what your denials are. I mean, what I care about is outcomes, and for you to explain to me how it is that I've ended up in prison, how it is that my brother's now ended up being kidnapped for the last 86 days. Those are outcomes. How it is that you have now benefited as a result of this police action recently taken, because this case was not going anywhere. So, I look at outcomes rather than for your denial of these things. So let me just read this again. I am unwilling to have my client further incur charges engaging in communications which are baseless allegations. So you don't want to incur your client having charges. Well, you know what? I mean, the reality is that the best course of action is for you to have a full-on frank conversation with me for an hour. Now what you're going to do is you're going to have to review this conversation. Not only are you going to review this conversation, not only is the Housing Association going to review this conversation, but the wider public are going to be reviewing this conversation. So your time that you're saying that you're trying to be efficient at, and this is just another excuse that you use, isn't it? Oh no, we have a duty of care to be efficient with the money, all right, with our time and resources, and that's the overriding objective of the courts, is to be efficient with the case management. And so I've heard it all before. You're trying to be efficient with the money. This case is now, I believe, 20 months later. You've not chosen to engage with me. You've not chosen to, try to resolve the situation out of court. Do you think it's going to get resolved any sooner now? Your client is already incurring tens of thousands of pounds, and they're losing money on a weekly basis that they could be receiving in a housing benefit, which your client is fully aware of. Let me just finish this. Let me just finish what you've just said then. Accordingly, if you wish to put any queries, whether based on settlement or otherwise, into writing, then we will review these and respond to those which have relevance to the matter. So he's basically saying, what my allegations that there's a joint enterprise fraud taking place, or which you and your client are net beneficiaries, is all baseless. It's all irrelevant. Let's just deal with the matter. And what they want me to say is, the settlement is that yes, I agree that we are lawfully trespassing. Here's the keys. Let me just vacate the property. Well, absolute rubbish. You know the fact that you have no case. Your case is absolutely without merit from day one. That's hence why your case was dropped. You, the housing association, dropped your case when I brought it to your attention that you've not even lawfully terminated the tenancy agreement. So don't give me the fact that you're going to be acting, you're going to be the sole arbitrator. There are many outstanding issues, and this level of complexity is simply getting more complex now, as you can see from the court action that you've taken. This is taking up the court's time and resources and public expenses, and it's designed that way because you've got a quid pro quo or relationship with the local authority. So let me just finish off what you're saying. These are responses to which are relevant. I do not propose to relate my clients. I do not propose to restate my client position on joint enterprise, nor my own. It is denied. So basically, I've made the allegation that they are committing joint enterprise fraud through the collusion of the councils and everybody else. And they're saying, no, we're all professionals. Look, we've got professional titles. In the case of Braveheart, I don't care about your titles. You can take your titles and stick them. I don't have any titles. The only title that you've given me is a convicted fraudster. And let's just look about this. All this case is to do with this fraud case. So you're telling me that you have no evidence. Like you see no evidence of joint enterprise fraud. Well, let me give you the evidence right now over this call, so everybody else can listen in on this call. Evidence. You know the fact that if you look in the case file bundle disclosure in this file that's taken place previously, that both my mother, the tenancy holder, and my brother Talib, whom you've now recently kidnapped, in April 2014, when your client's agents Nazneen and Jonathan Cole came down as a result of me making threatening allegations against my brother Talib, both of them came down and both of them witnessed both my mother and my brother sign over what was deemed to be a power of attorney document, conferring their power of attorney to me. That was done in April 2014, at a time when your client, the housing association, were in open dialogue with Bradford Council, Bradford Council's criminal investigation at the time. So the housing association, were taking instructions from Bradford Council to come down and visit my brother Talib. And I said, well, Talib is not the client. Talib is not the client, is it? He's not the tenancy holder. So why have you come down? I instantly realized what was the situation then, and the fact that your client has had a back channel of communication and acting in the council's best interest. So I took that opportunity to get my mother and brother to authorize me with their lasting power of attorney. Those are two documents. Now, those two documents, while there was a live criminal investigation being carried out by Bradford Council, should have been handed to from Manningham Housing Association to the council fraud investigators. If those documents were handed to Bradford Council's criminal conviction against me would have fallen apart, because obviously I had registered my mother and my brother's wishes to authorize me to take care of their finances with your client, the housing association. Now it happens that subsequently, because that was not forwarded, there's a liability on your part. You are responsible for that. When I say you, I mean you, the housing association, are now responsible for my criminal conviction of 2016, because my mother and my brother, the tenancy holder, my mother, had forwarded their power of attorney and registered it with the housing association. And to say that there was no channel of communication between the housing association and the local authority back in 2014 is quite clearly a falsehood, because of that channel of communication, the housing association agents Nazneen and Miss Jonathan Cole came down and as a result to check on my brother, who was not the tenant. At that convenient time, I took the opportunity to get both my mother and my brother to sign a document that was a lasting power of attorney in front of two people. And Nazneen fully understood, who could speak the language and she understood what was going on. So they witnessed it, but I refused to act as witnesses. I then subsequently sent those into the housing association. That's clear evidence there that shows that the local authority has given instructions to Manningham Housing Association agents to come down and do a checkup on Talib, who was not the tenant, not my mother, but my brother Talib. So there's that channel of communication. Then subsequently, as a result of which, those two documents, the power of attorney documents, as I claim them to be, should have been sent to the criminal investigation of Bradford Council. That did not take place. Subsequently, I was unlawfully criminally convicted under a joint enterprise by numerous people. So I don't want to go into that. But subsequently, in 2017, I've come out of prison in 2017 and re-entered the property where my mother was residing. And in 2018, my mother has given me her lasting power of attorney, a formal document that was registered with the Office of the Public Guardian. As soon as that was given to me in February 2018, and by June or July 2018, that I had a copy of this. I purposefully did not give that document to show it to anybody else because I wanted to establish that this channel of communication. So the first person I showed this registered Office of the Public Guardian, registered lasting power of attorney to, was your Mr. Jonathan Cole. And as a result of which, Mr. Jonathan Cole got in touch with Bradford Council's fraud investigator, saying, well, look, what do we do here? Because we assisted you in sending this guy to prison, and now he's presented us with a lawful document, and he's asking for disclosure of the tenancy records. So that happened in July 2018, as a result of which I then subsequently, through numerous requests throughout 2018, towards the end of 2018, you finally released to me the documents that I required, basically these power of attorney documents, which then would have clearly undermined the local authority's criminal conviction. By this stage, the local authority had instigated court of protection proceedings in relation to my mother to undermine that lawful and registered lasting power of attorney. So the original lasting power of attorneys were written and drafted by myself, not registered with anybody other than the Housing Association in April 2014. But then my mother in 2018 giving me her formal lasting power of attorney, which was registered with the Housing Association, with the Office of the Public Guardian, and submitted to the Housing Association in July 2018 to Jonathan Cole, who then let the cat out of the bag, effectively, as the terminology I've used, to inform the fraud investigators at Bradford Council of this document, which obviously Mr. Cole could see was a conflict of the would undermine the criminal conviction of the local authority. So he was effectively acting as an agent for the local authority. That's all clearly documented in the documents that you have before you. Then, as a consequence of that, the local authority then colluded with the Office of the Public Guardian to have that undermined and instigated court of protection proceedings at the end of December 2018, all through 2019, 2020, 21, until January 22, when my mother was unfortunately murdered. But what happened then was that my brother's original power of attorney documents registered with yourself were being redacted. So in 2019, I got my brother Talib to also sign over his lasting power of attorney and register it with the Office of the Public Guardian, thus enabling me to get an unredacted version of those two power of attorney documents that were registered with the Housing Association, your client, in 2014. So now you're fully aware that those two documents exist. As I would call them, informal lasting power of attorney documents, which were registered with the Housing Association in 2014, and then subsequently the Housing Association client, I've been fully aware that I've got formal documents regarding the registering the lasting power of attorneys with the Court of Protection, the Office of the Public Guardian, and those subsequently have been removed through the collusion of the council, subsequently resulting in my mother's death, which I'm obviously premeditated. But let's just get back to this evidence that you're saying of collusion. Quite clearly, clearly there's a channel of collusion taking place between your client, as you have already disclosed to me in your evidence bundle. Even when we returned back in February 2022 to the property, when you're alleging that we're unlawfully trespassing, the housing association, your client, have contacted Christopher Browell to raise a false flag safeguarding alert in February 2022, and Christopher Browell has written back saying, we at this moment in time we've got no welfare concerns. So your client, Manningham Housing, looked to instigate and trigger a false flag welfare check in February 2022 when we returned to the property. That failed. Then in August, everybody's colluded and conspired. Your client has then through your under the instructions of your client, have then put in a gas safety inspection check with penal notice, which was granted in before District Judge Foster at the end of September 2022. And by October, you've sent gas safety engineers, whom I preemptively knew what you were up to, and did not allow them into the property. But then subsequently, which has then triggered a welfare check on the 14th of October 2022 last year. So you see how you are all working, colluding, conspiring together to instigate a welfare check in order to abduct my brother. So it's not the case that, my brother's now been abducted in August under the joint enterprise through your involvement. It was all underway through your predecessor, Kate Joss's involvement in August, September last year, and October, and that all failed. So this aspect of you attempting to collude with the authorities, everybody colluding to kidnap my brother, has been an ongoing theme for a number of years, because obviously it's not in the local authorities' interest for me to be caring for a person that they themselves have criminally convicted me for. So then coming back to this point about evidence and about your dumbfoundedness now that, I don't understand what's going on, through your willful ignorance. Mr. Jonathan Smith, as a senior solicitor at DWF, you answer me this simple question. How can it be that I've been criminally convicted of the people that are in my care, gone to jail, all right, from January 2016 until July 2017, and then come back and return to provide the very care to the people that I have been criminally convicted of? Give me that answer. Go on. That's a logical fallacy that you're going to now act dumb on, that you don't understand. So take that into consideration, that you can't answer that question. And then subsequently, after I've been released and come back to my care, both my mother and my brother have formally signed over their lasting power of attorneys in 2018 and 2019, registered with the Office of the Public Guardian, and then needing to be invalidated, not through yourself, but through the Office of the Public Guardian and the Court of Protection, and buying off the judges there. So you see that is, just answer this simple question. What has my criminal conviction got to do with either my mother or my brother's mental capacity? And the answer is nothing. My criminal conviction has got nothing to do with their mental capacity. And as a result of which, subsequently, they have given me their lasting powers of attorney, registered with the Office of the Public Guardian, and we're in this situation today because of this joint enterprise collusion. So rather than saying denying everything, which anybody and everybody does, so even the Prime Minister denies going to the parties, that it's now coming out the truth. Look at the outcomes. I've been criminally convicted for what? For caring for my family members, all right? And as a consequence, I've lost out of, £750,000 that the local authority have stolen from us, all right? That's one consequence. I did not get to see my mother for the last 334 days of her life while I was kicked out of the city. Now my brother's been kidnapped. I've not seen him for the last 86 days. I don't care about what you're saying, that denial, it's not because of this or because of... Look at the outcomes. Look at what objectives you're achieving. You've managed to achieve the basically derailed and these court proceedings. The biggest defense I have, or the biggest value I have, is caring for my brother in this house. Because he's been taken now, I've lost all legitimacy in my case. And this is why I'm saying you are pervert. This is why I'm saying that you, the Housing Association, in collaboration with West Yorkshire Police and the Council, have effectively perverted the course of justice. That's what you've done, isn't it? That's the allegations that I've made, because you've just perverted the course of justice. Why has my brother been arrested? No, sorry, why has my brother been taken? What have I done? What has been proven? The local authority simply came down and arrested me. I still don't know what's been proven or what is factually correct. For 86 days, I do not know where my brother is. And you, as a solicitor, knows that this is a clear violation of the Human Rights Act, the right to privacy, Article 6 or Article 8. You cannot do this, what you've done, by kidnapping my brother like this. And now you're sitting back singing Dixie, saying we don't know what's going on, all acting dumbfounded, like, I don't know, it's not my fault, look at him, pointing fingers at each other, when the reality is that you're all colluding and conspiring. And this is one of the reasons that you're hiding behind the corporate veil and refusing to engage with me and refusing to speak to me, because I'm going to ask these damn straightforward questions. Hey man, you're in a position of power, you're in authority, tell me what you've done. How has this happened? All right, and obviously it's not the case that I'm simply making allegations against you, Mr. Smith. You're, like I said, you're a small cog in this whole joint enterprise. All right, it's more importantly the judges that are involved, and you were there at the meeting where you were there at the hearing when both you and I attended on the 18th of July before District Judge Mitchell. And I even told him then, did you listen to my recording with the Annie Bateson, the solicitor of October 2018, yes, when I was quite clearly, before all these court cases, these recent court cases in the Court of Protection got underway in October 2018, I've left a voice message with Mrs. Bateson clearly saying, look, the jig's up, you're going to have to buy us off judges. And they never failed to disappoint, did they? They bought off all these judges. I've got a whole list of judges. So I don't care about you as a solicitor, all right, saying that, oh, I'm denying something. You're all Orwellian pigs eating from the same trough, and your small piglets, they're the biggest hogs, are the senior judges who have made clear allegations to. This case has been rambling on for 2 years, and the reason it's coming to be nearly 2 years is because of a failure of the judges to recognize the truth. Your case has no validity. The housing association should have simply given us a tenancy agreement, and they could have been making money right now. And as a consequence, all they're doing is looking to expose fraud and corruption, and as a consequence, I am suffering. I'm going through human suffering. I've lost my brother. I do not know where he is for the last 86 days, and this is all because District Judge Mitchell on the 18th of July failed to put a penal notice in order to get this capacity assessment carried out. Now you tell me, Mr. Smith, that how can it be that the housing association are willing over and over again to pay £1,000 for a capacity assessment to be carried out when you know that a capacity assessment is not even necessary? So you're telling me on the one hand that, oh, you're looking to, act in your client's best interest to save money and costs. Then why is your client willing to pay over £1,000 to get a capacity assessment carried out? A same capacity assessment that the local authority, Bradford Council, have been trying desperately to do all through 2020, 2021, and 2022. They've been desperately trying to get High Court judges, namely District Judge Beckley, to give orders and penal notices for me to get my brother a mental capacity assessment carried out. I know exactly what's going on here, and so does the judges. District Judge Wilcox knows that in order to get the official solicitor involved to act on behalf of my brother, so you can use him as a legal aid benefit mule, you need to first of all get the fact that he doesn't lack mental capacity, and then instruct the official solicitor to be his litigation friend, when the reality is that I could be his litigation friend. And you were at the hearing last time before District Judge Wilcox, who was giving me some gobbledygook that I can't be. The law doesn't work that way. Now you see that even District Judges are so mentally retarded. They're telling me that the law works in a way that's obviously clearly contrary to how the law actually works. The District Judge Wilcox didn't even know that I could take a legal action of contempt of court against you as a corporation. So, don't tell me that you're ignorant of these facts. You are fully conversed in everything that's going on, and your defense is that, oh, what we'll do is we'll just act malevolent, we'll just act with ignorance and stupidity, that we don't know what we're doing. Okay, Mr. Smith, I will now continue to leave voice messages to you every single day, as I have been doing for every single day to both Christopher Browell and Mr. Kenner. And so, in order for you to see, I'll send you the link. I'll email you after this voice message. I'll show you the link. Go to the YouTube channel, see all the other messages that I've sent out to both Christopher Browell and Mr. Kenner, making the very same allegations, simply saying, no, we did not do it. It's completely completely without merit. These unfounded allegations will not excuse the fact that the truth, the only way that this matter can be looked into, it needs to be independently, may I add, to be investigated. You are not going to be like the Prime Minister Boris Johnson and simply state it's not true and I'm the Prime Minister and you should listen and trust me. We do not trust you. You're all liars. Okay, and so similarly, I'm making the clear allegation. I've continued to make that allegation. I'll continue to make it to my last dying days. The local authority are privately commissioning out numerous organizations and making them subservient because they're effectively looking to cover up their failures in adult social care. They were making direct payments to my brother for 5 years and were not auditing the money, and that's the real reason why I'm being persecuted and victimized by everybody. From 2006 to 2012, the local authority were paying out £410.70 to my brother in direct payments and then were failing to audit it. I was holding on to this money so I could then publicize their failures, and they then all colluded and conspired and said that I hadn't spent the money and therefore I was acting unlawfully, illegally. That's absolutely ridiculous, and ridiculousness has happened in this case so many times. The local authority have then colluded and conspired with High Court judges to kick me out of the city, saying that I've got no right to live here, thus endangering my brother Talib's life. And it's all just fraud and deception and corruption, and you must, and anybody else, you obviously are going to deny it, and so is the judges and everybody else and the council saying no, you can trust us. But you know what? The people aren't stupid. My fellow citizens are not stupid, and hence why I'm publicizing these recordings so everybody can listen into the fact that you're all lying, cheating, conniving Orwellian pigs that are at the trough, who are trying to scam us and making us suffer, and obviously you're then placating us with your privileged positions, and no doubt this is racially motivated. No doubt this is as a result of Islamophobia and xenophobia that me and my family are being subjected to this. Now everybody can listen to this conversation. So you had an option to talk to me, all right, directly, and you chose not to do that. We could have had a private conversation. Now we're going to have public conversations, and I'd have a right to record any conversation I'm involved with and publicize it, because to expose the lies and deceptions and the corruptions that you people are committing. Why are you so embarrassed for? Why would you refuse to be open and transparent? Why would you refuse to come on the public record? This is now on the public record. Everybody can listen into it. The fact that you're manipulating us and causing us harm, suffering, and distress. I'm going to end the call here, but you'll get a message from me every day, every single day from now on. I urge you once again to engage with me in direct communication so we can look to resolve the situation.